while they're here.
Right, I'm just going to ask Ms. Wenzel to do an opening statement real quick, because obviously there's a lot of interest in your role also. We're going to have a lot of questions, and we are running low on time, so thank you.
I have been asked to address, good morning, and thank you for inviting me. I'm Joanne Wenzel. I'm the chief for the Bureau for Private Post-Secondary Education. I have been asked to address a number of issues today, so I hope to be able to get through that quickly. Enforcement, how the Bureau for Private Post-Secondary Education provides enforcement, an overview of the Student Tuition Recovery Fund, a chronology of the events leading up to the closure of Corinthian, and to provide some lessons learned. A brief overview of the Bureau. In 2010, we were established in the Department of Consumer Affairs. The Department and the Bureau have worked diligently to create an organization and infrastructure to implement the California Private Post-Secondary Education Act of 2009. We are directed to regulate private post-secondary educational institutions by creating a structure that provides an appropriate level of oversight, establishes minimum operating standards, resolves student complaints, ensures institutions provide accurate information, and ensures stakeholders have a voice. The Bureau also investigates unlicensed activity and administers the Student Tuition Recovery Fund. Enforcement of the Act. The Bureau has three main tools for enforcement of the Act: compliance inspections, investigations, and emergency decisions. The Bureau has a mandate to conduct on-site compliance inspections to review institutions. If during a compliance inspection a violation is found that is minor and technical, the institution is issued a notice to comply and is given 30 days to provide evidence of compliance with the law. If the institution does not respond to the notice to comply, or if the response is not sufficient, a citation may be issued to the institution. If during a compliance inspection the compliance inspector finds evidence of material violations of the law, a referral for an investigation is made to the enforcement unit. During compliance inspections, inspectors review files, verify that information that has been provided to the Bureau is accurate, interview faculty, administrators, and conduct student surveys. The student survey process includes providing students contact information for the Bureau in case they want to contact the investigator, the inspector outside of the institution. Compliance inspections are prioritized utilizing, among other things, the factors outlined in SB 1247. Because institutions that are approved by means of accreditation have a streamlined application process, institutions that have not been subject to Bureau approval prior to being approved by means of accreditation are factored in the prioritization formula for compliance inspections. The Bureau has a mandate to investigate complaints. Complaint investigation includes, among other steps, reviewing the complaint, confirming the complaint, analyzing the case, gathering evidence, conducting interviews, logging and reviewing evidence, conducting follow-up, and writing reports. If, as the result of an investigation, the Bureau finds evidence that the institution violated the Act or regulations, citations may be issued for up to $5,000 per violation of the Act, or in the case of operating an institution without approval, $50,000. The Bureau may also issue an order of abatement that requires an institution to demonstrate how future compliance with the chapter or regulations will be accomplished. In all cases, due process and appeals must be provided to the institution through a formal hearing process in compliance with the Administrative Procedures Act. As a result of an investigation, and if warranted based on sufficient evidence, the Bureau may take an administrative action against an institution and place the institution on probation, suspension, or revoke an institution's approval to operate. When these types of actions are taken, due process must be provided through the Administrative Procedures Act. The entire process can take anywhere between 15 months to 2 years to complete. Finally, if the Bureau determines that it has sufficient evidence that an emergency decision to protect students is warranted, the Bureau may take an emergency action against an institution and order the institution to cease enrolling new students, stop instructing, and stop collecting tuition. If the Bureau takes an emergency decision or emergency action, it is in compliance with the Administrative Procedures Act and must be followed with a formal administrative action. The Student Tuition Recovery, I'm going to move into the drift now to try to speed things along. The Student Tuition Recovery Fund was created to relieve or mitigate economic loss suffered by a student while enrolled in an educational program at an institution not exempt from the Act. The student must be a resident of California or enrolled in a residency program. prepaid tuition, and suffered economic loss. STRIF is funded by assessments on students and is based upon the dollar amount of the tuition paid. Since 2010, STRIF assessment rates have been as high as $2.50 per $1,000 of tuition and as low as $0, and the assessments are made quarterly. The amount of assessment has changed because of the statutory cap and floor on STRIF. The Bureau is currently in the lengthy process of promulgating regulations regarding STRIF. The regulations will, among other things, allow payments for loss of educational opportunity. Currently, students that receive grant money or funds paid on their behalf do not have eligibility for those funds. That would include Pell Grants, Cal Grants, or Veterans funding. This change will directly benefit veteran students by allowing those that have received benefits from veterans educational programs to receive credit of money paid on their behalf for payment towards future educational opportunities at different VA-eligible institutions should they have closure of the institution they are attending. That's STRIF. Now I'm going to get into the chronology of Corinthian. In the fall of 2013, the Bureau received information about the suit filed by the California Attorney General against Corinthian colleges. The Bureau immediately opened investigations on 13 Everest and Wyotek College locations, which were all of the Corinthian colleges under the purview of the Bureau. In addition, each of these locations was prioritized for additional compliance inspections. From January 2014 to May 2014, announced compliance inspections were conducted at all Everest and Wyotek locations. The Bureau was notified in late June 2014 that the United States Department of Education was placing Corinthian colleges on heightened cash monitoring because of the institution's continued delays in responding to a request for records. As a result, the institutions were mandated to wait 21 days to draw down funds from the Department of Education. The Bureau's investigations were ongoing. In early July 2014, the Bureau was notified that Corinthian colleges had entered into an agreement with the United States Department of Education to sell their California locations. The agreement, among other things, documented that the Department of Education would continue to disperse aid to Corinthian colleges, and a monitor would be put in place to oversee expenditures of the institution, as well as the sales.
I just want to interrupt for 1 second. Does your organization have the authority to look at the parent organization, unlike WASC does?
Well, we look at we look at the institution. So when it comes down to looking at parent organization, it would really be if the parent organization is the financial backer of that institution, then we can look at the financials. But as far as what the motivations are of the company, keeping in mind that a lot of times these companies, and I can't speak directly to how Corinthian was organized, but a lot of times there are subsidiaries for those organizations. So you may end up with multiple, I know Corinthian colleges had Corinthian, and then they had their California schools, as they had 84 other locations in other states in Canada, an online division. So to a point. The answer is, I guess, to a point we can.
So hopefully we've learned something here to make sure that...
Oh, we've learned a lot of things.
Okay.
So as a result of the information, in July of 2014, I personally visited several of the Corinthian campuses as I wanted to see for myself what was actually happening on the campuses. I verified that faculty was indeed on campus, classes were being conducted, and as part of the agreement with the Department of Education, disclosures were provided to students that the institution was for sale. I spoke with several faculty and students at each location in an effort to gauge their satisfaction and concerns, and our investigation was ongoing. Between January 24th, 2015 and February 24th, 2015, the Bureau conducted unannounced compliance inspections on 11 Everest and 2 Wyotek campuses. In early 2015, the Bureau learned that California campuses would not be included in the sale of the Corinthian campuses. In March 2015, the Bureau was notified that Corinthian colleges was being asked to post a letter of credit for $34 million by the United States Department of Education for past year performance. April 15, 2015, the United States Department of Education issued a letter of intent to levy a fine against HEALD. And while HEALD was not under the jurisdiction of the Bureau, it is owned by Corinthian Colleges, and the fine would have an impact on the overall fiscal capability of the organization. On April 17th, based upon evidence of financial instability, the Bureau took an emergency action and on April 23, 2015, filed an accusation against Corinthian Colleges, which is still open and ongoing. On April 26th, Corinthian announced that the campuses would be closing. On April 27th, the Bureau identified programs that were designed to lead to employment in a licensed occupation and worked with the licensing board in order to facilitate transfers or teach-outs for those students, and made arrangements for staff to meet with Everest and Wyotech students. On April 28th and 29th, 2015, the Bureau deployed staff to all Everest and Wyotech campuses in order to deliver information regarding STRIF and school closures to all available students. Approximately 26 Bureau staff spoke with over 3,500 students, which represented approximately 80% of the students that were enrolled at the time of the institutional closure. Students were provided closed school brochures, STRIF claims, information regarding student loan discharge, and copies of transcripts.
I want to sort of reiterate this timeline and maybe just get right to the point. Basically, it was 10 days before the closure that you took action, and at that point, obviously, the damage had been done. Why did you act so late? Maybe I know there's been a long explanation about waiting periods and making sure that you had all the information, but like sort of succinctly, why did you wait so long, and how would things be done differently? And then the three-part question: what do you count on accreditation? Does that have to be part of the equation also?
No, accreditation is not part of the equation. As far as why we waited for long, our investigation was still ongoing. Our investigation had not been concluded. Keeping in mind we were looking at 13 separate campuses, and it was a relatively short period of time that happened. But based on the circumstances as are outlined in the accusation, which is the requirement for the letter of credit and then the intent to levy a fine, that's why we took an emergency action and not an accusation. So as far as lessons learned, given the Bureau had 2 field investigators at the time of the commencement of the investigation of the Corinthian campuses, one lesson learned is that more staff is better when trying to cover investigations of that many institutions. That is a problem that is being addressed, and we thank the legislature for its support in that effort. We learned that staff needed additional training on review of the performance fact sheet. As a result, a new training program was developed for all BPPE staff on the requirements for performance fact sheets and how to review them. Staff training was previewed in late 2014, reworked, and provided to all staff in early 2015. Training on the performance fact sheet is part of training for all new employees. Regardless of the number of staff, prioritization is key to working efficiently and effectively. We are in the process of identifying at-risk schools and are ensuring that they are appropriately reviewed. In addition to the creation of a prioritization matrix for inspections and investigations, the Bureau is currently working on the creation of a specialized unit within the enforcement section that will be devoted to reviewing performance fact sheets, financial statements, institutional websites, and other key areas for disclosure of institutional information. The goal is to be able to identify issues and document evidence earlier and aid in the prioritization of compliance inspections and investigations. And finally, the Bureau has always had working relationships with the United States Department of Education, accreditors, and licensing agencies. One of the lessons learned is that expanding that circle of working relationships to include agencies that provide funding sources to institutions, such as the California State Approving Authority for Veterans Education, the Student Aid Commission, and Employment Development Department, can be very helpful in identifying institutions facing challenges earlier, so we may better be able to get them corrected and avoid school closures altogether.
I think, I just want to emphasize that last part. There was, from what we heard from CSAVE, there was really very little communication from the meeting on July 8th, 2014 till the doors closed. So I would reiterate that communication between these different agencies is extremely important, basically to make sure that we do not allow this to happen again. Did you have?
I'm sorry. Wanted to ask Ms. Wenzel one question, and that is, what are you doing now to ensure that this never happens again?
Well, we're stepping up. As I said in the lessons learned, we are stepping up. We just received additional staffing in this budget, in this year's budget, which went into effect on July 1. So we are, with that additional staffing, we are creating a specialized unit that will actually work at looking at annual reports and being able to identify potential issues earlier. The whole hope is that we can identify these issues earlier and get them corrected, if possible, so that we don't end up with students in the street.
Now, with the students that were caught in the process of Corinthians closing, what can we do to make them whole?
Well, there are currently the students under the jurisdiction of the Bureau are eligible for STRIF, and we are helping them with student loans discharge. So their federal student loans are dischargeable. Sometimes private loans are dischargeable. When Corinthian sold their out-of-state campuses, there were a number of private loans, $12 million worth of loans that were discharged under that, basically paid off by the proceeds of that sale. So there was some relief in that area, and the Student Tuition Recovery Fund is available to them so that we can mitigate economic loss. Keeping them whole, you can never give them back the time that they spent.
That's what I wanted to hear, because when I saw them on television, when I saw them, the students on television, crying that they have poured their lives into improving their lives, how do we go back and maybe even use some of those classes so that they can do something with the classes that they've already enrolled in and passed?
And many of the other institutions have accepted students for transfer, but that is based upon it's an institutional prerogative, basically, to look at how much they'll take as transfer credits.
Thank you.
And the veterans, especially, it's a big loss. Not only 2 years, but they're losing their living stipend. I mean, that does not come back either. So it makes it much more difficult to go back to school when you don't have that additional benefit anymore. I really appreciate all three of you. We have about 5 more minutes and 2 more panelists. So thank you very much for answering these questions.
Thank you.
And can we get our last 2 panelists up, please? All right, so we have Robert Sumner, who is with the Office of the Attorney General, and Robert Muth, who is the supervising attorney for the University of San Diego Veterans Legal Clinic. And sorry that you were at the end. You'll just have to talk really fast.
Not a problem. I can leave it to the salient details.
Okay.
I know that a lot of my colleagues have already spoken extensively about the situation, and we've partnered with many of them, so I imagine a lot of it was covered. Just to stress at the beginning that consumer fraud scams targeting veterans has been a priority for the AG since she took office. We formed a working group. We've worked closely with that population because they are so susceptible to very targeted scams. And also just there's a social egregiousness that comes with these types of activities, even beyond what is already a pretty reprehensible practice. This was a focus of our Homeowner Bill of Rights. This was a focus of a lot of our work through the consumer law section. When we went through the process litigating against Corinthian colleges, one of the things that we were particularly appalled by and outlined in our complaint was the way that they targeted veterans specifically in their advertising. One of the charges that we have in our complaint and our litigation, which I can't speak about too extensively, but I can say is still continuing through the process, involved the unlawful use of military seals that lent the appearance of some sort of endorsement by the U.S. military branches of the institution and its programs, when in fact there was no such endorsement. They operated websites like healedmilitary.com that continued to stress this idea that there's a correlation between, post reentry from the military into Corinthian colleges that would create an endorsed path by the government into the private sector or the public sector beyond military. So that is one of the charges that continues to be alleged in our complaint. And then, throughout the post closure process of HEALD, as we've seen these schools shut down, the AG has always wanted to make sure that it's a priority to think about the students. The day that we filed the complaint, that was essentially what our minds were already on, was what happens when inevitably these students have to find somewhere to go after HEALD. And so that's one of the reasons why the AG has made outreach a priority, and we've operated a web tool and done a lot of outreach efforts to bring information to students about what resources are available to them. One of the resources that's available is through the San Diego Law School Veterans Clinic. There's also another clinic out of Santa Ana, and these provide veteran-specific services that helps them with a number of their benefits, especially because many of them do carry benefits because of the 90-10 exemption for the GI Bill. So that's been the focus right now, is just on outreach to those students. And also we are happy to support Chair Medina's bill, AB 573, and we've been working to make sure that that specifically addresses situations where, there's National Guard, education assistance grants, and things like that that should similarly be repaid like the other types of loans. So that's been the focus of the AG. And again, we are continuing to pursue the litigation, but in the meantime, we've been partnering a lot with members of the legislature to get those resources out to students because so many of them are veterans.
Thank you, Madam Chair. Thank you, members of the Assembly. I appreciate the opportunity to speak with you today about this important issue. My name is Bob Muth. I'm a clinic professor at the University of San Diego School of Law. I'm also a Marine Corps veteran and an Iraq War veteran, so this issue is near and dear to my heart. I have the opportunity, as part of my duties at the law school, to supervise a legal clinic that a gentleman just referenced, where we provide free legal assistance to veterans and their families. Unfortunately, the largest percentage of our case practice right now is assisting veterans who are in disputes with for-profit schools. Obviously, as Corinthian shut down, you would not be surprised to see that we got deluged with calls. I think it's important, though, to note that there is a striking similarity between the types of complaints that the veterans are informing us of with respect to Corinthian also exists in the calls that we are seeing on a daily basis from other schools within the for-profit sector. So I think this is a problem that's going to be ongoing. Unfortunately, I hate to say that. I don't think the Corinthian situation is sui generis in that respect. Obviously, a number of members of these
Can you go, I'm
sure.
really sorry to interrupt. Can you go into it a little bit more? You're talking about the type of complaints that you're getting from the Corinthian students are similar to the type of complaints you have from other for-profits. So could you go into some of those complaints and specifically focusing on the veteran students? And we're not stopping right at 11, but because we really do want to hear what you have to say. I'm just trying to be as close to 11 as possible, but we do want to make sure that we get that good information from you.
That's great, and I think that's a great question. So the types of complaints we see are often with respect to veterans being promised certain job placement rates that are absolutely fraudulent. Promises of assistance with respect to job placement after graduation that don't materialize. Schools that have informed veterans that the school is accredited in a way in which it is not, which will impact whether or not that veteran who has just completed a course of study will be able to actually sit for licensing exams and that sort of thing in their desired career field. We've also seen veterans who've been promised that their credits will transfer to other institutions, basically as a recruitment pitch in order to induce the veteran to use the school kind of like they might use a community college and then hope to go on to a 4-year state institution. We've even seen, specific to veterans, really outrageous practices where the veteran will inform the school that they have some sort of a service-connected disability. The school will tell them that they will be able to provide reasonable accommodations to assist that veteran, and then when the veteran actually tries to avail themselves of those services, they simply don't exist. So we've seen, in those capacities, they're similar to what other students, non-veteran students, are seeing, but it's particularly, in my opinion, abusive when we're talking about folks who have raised their hand and served their country overseas. So those are the types of issues we've seen with respect to Corinthian specifically, but also more broadly within the industry generally. I think one other piece that I just want to refer to that was discussed earlier is it's very important to note that I think CalVet did a great thing by shutting off the post-11 GI Bill benefits when they did, but there was still a number of veterans who were attending Corinthian schools right up until the closure, specifically because there's other programs that the VA funds with respect to training and education benefits that could then allow those students to go to the school. So, for example, there's a vocational rehabilitation program which is targeted at the most vulnerable veterans. These are ones who have significant service-connected disabilities and are trying to make a successful transition to civilian life. And oftentimes the appointed vocational rehabilitation coordinator at the VA was the one referring these veterans to go to Corinthian, even after CalVet had done their duty and pulled those funds back. So a number of the folks that are contacting us were going right up until the bitter end on vocational rehabilitation benefits. There's also veterans who, once CalVet made their decision, and I think it was the right decision in 2014, continued to stay on at the school and incurred significant student debt. So we have veterans who have expended all of their GI Bill benefits or their vocational rehabilitation benefits and have sometimes incurred up to $10,000, $20,000, $30,000 in student debt on top of that. So it's a very complicated picture for the veterans because some of those monies they might be able to get back through the Department of Education's process or through the STRIF, depending upon how that money was paid. But with respect to the VA-specific funds, it's unlikely, at least at this time, that money is going to be returned. Particularly outrageous as well is that when these veterans who were going to those schools on vocational rehabilitation funds then had the school shut down on them, their rehabilitation coordinators are now referring them to other schools that are troubled within the industry. And I'm afraid that we're going to see the same thing happen again, where these folks are now shuttled from one school to another, where the schools keep closing down. So I think we've seen those types of issues. Does that answer your question, ma'am? Okay. The only other thing I'd like to discuss, and I know we're very brief on time, is some of the potential reforms. Although I do think it's important to note that the Attorney General's office has done a fantastic job in being one of the first to recognize that this was a serious issue and bring meaningful litigation on behalf of California's consumers. I think California's Department of Veterans Affairs, specifically CSAFE, has done a fantastic job with respect to the way in which they've tried to protect student veterans. They're seen as a national leader, in my opinion, with respect to state approving agencies. I think they're a good example of a way to maximize and leverage resources, even though they could certainly use more funding, in my opinion. I think with respect to reforms, I would start with the list that was provided to you by CalVet. I think that's a great place to start. I think a bond would be an important potential piece of this puzzle. I think in addition to funding assistance to CalVet, it makes sense to go and revisit those requirements that were proposed under AB 2099 by Assemblymember Frazier with respect to graduation rates and loan cohort default rates as well. I think those are baseline, reasonable expectations that a school should be able to meet if they want to receive our hard-earned taxpayer dollars, and those veterans are going to be able to use their GI Bill benefits. Finally, I think BPP needs to do more. With respect to HEALD specifically, there would have been an exemption because of the fact that they were accredited by WASC. And I do question, I'm not an accreditor, but I worry about the academic excellence, so to speak, of HEALD. The stories I've heard from our clients with respect to the type of education they were getting was atrocious, quite frankly. Students who were telling us that they had tried to make a transition into various fields, only to find out when they sought employment that employers would tell them the training they got was completely worthless. So I think that's
I just want to have you go into that a little bit more, because I would like to know how much of a role you think the accrediting agency plays, and WASC did say they would have kept HEALD accredited. So should they be measuring by different academic what are the standards that they should be measuring by?
Sure, and I'm not an accreditor. I don't claim to be
I understand. Yeah, so, but you have other great experience. So.
Sure. So my concern is this: when I go out and do outreach to veterans, one of the things we try to tell them is how to make a wise investment in their post-9/11 GI Bill benefits. And so, as a shorthand for that, we want to be able to tell them, look for the school being regionally accredited, because we need to have something. Because quite frankly, these folks aren't experts on where they're going to invest their hard-earned GI Bill money. And so, when you have schools that are able to apply for and receive regional accreditation, it makes it very difficult for a student veteran, somebody who might have been serving in Iraq or Afghanistan just 6 months before, to try to evaluate a school and the representations being made. So when they see that Veterans Affairs, Department of Veterans Affairs has approved the school, that it has WASC accreditation, oftentimes they won't do quite the same due diligence they might do otherwise because they feel like it's got the stamp of approval. So I think there needs to be a deeper dive into the actual quality of the programs that are being provided, because when you hear some of the stories of the type of testing that's being done, or the fact we've got a veteran who was pursuing a degree in an IT-related field, where when she got out, she found out that the actual program was instructing her on software and systems that were over a decade old, which within the IT field is completely worthless. She didn't even know. She's out there just pushing a resume, trying to do the best she could, thinking it was something that was wrong with her, until finally somebody pulled her aside and said, this is the problem. The degree you got is completely worthless. And so when I see that, it's infuriating, because this is somebody who tried to do the right thing. I mean, they did exactly what we wanted them to do in order to try to make a successful transition. and then they basically got taken advantage of by the school. I think the BPP needs to do more as well, though, because at this point, we're going to see this happen again. And so a number of these schools are now coming under the aegis of the BPP. And while Calvet is doing, I think, their part, they're somewhat limited, as we heard today, with respect to what they can actually do. They basically have the nuclear option of taking away the money or not doing a whole lot, a very limited suspension. Whereas BPP has a whole panoply of different options, and I understand that there's different due process rights that are affected when we talk about the BPP versus Calvet. But that can't be an excuse to not do more. That's where I think this.
And do you have a suggestion on what that more is? I mean, you heard the lessons that they learned.
See, but I guess where I come from in the Marine Corps, that's the answers I heard were not acceptable. Either you did the job or you didn't do the job. And if you can't do the job, we're going to find somebody else who can. I hate to be harsh about it, but that's what it comes down to. And so, in my opinion, I think this was completely predictable. I don't think that there was anybody who's an expert in this field that didn't see this coming about a year ago. And I can't understand how students in California were still being enrolled as recently as right up until basically the time that the school collapsed. There has to be something more that can be done. I think that there are tools in place within the regulations as they exist that they can do more. And I hope that they will do so on a number of these schools that I think are going to come before us again here in the next year.